Welcome to the Employee Benefits Lunch Break webinar series with Miller Johnson. My name's Nate Caverly, and I'm an associate attorney in the Employee Benefits and Executive Compensation Group here at Miller Johnson. We have a few more webinar dates coming up this year. We have one on September 18th and one on November 20th. If you have any ideas for topics for the future webinars, we're happy to hear any ideas you might have, and we might include those during the future presentations. This is the 2024 Mid-Year Employee Benefits Recap and Outlook. Today I'll be discussing 5 topics, the first being the recent Supreme Court decision that ended Chevron deference, legal challenges to the Affordable Care Act's preventive care mandate, the Department of Labor's ESG rule, the DOL's new definition of an investment advice fiduciary for purposes of ERISA, and finally, the Federal Trade Commission's non-compete ban. First, I'll start with the end of Chevron deference. Chevron deference is important because it's been a foundational element of federal courts deferring to federal agencies' interpretations of statutes. It's named after a 1984 Supreme Court decision in Chevron USA versus National Resources Defense Council. Like I said earlier, it required federal courts to be deferential to federal agencies' reasonable interpretations of ambiguous statutes. Chevron had a 2-part test. First, whether Congress has directly spoken to the precise question at issue. If Congress had spoken to the precise issue, then the court would follow the intent of Congress, not the agency. But if they hadn't spoken to the direct issue and the text was silent or ambiguous, the court would defer to a reasonable agency interpretation. The case that overturned Chevron deference was Loper Bright Enterprises v. Raimondo. This happened very recently, and right now there's been an influx of employee benefits litigation brought after Chevron deference was repealed. It replaced Chevron deference with the best interpretation standard. And some deference will be granted to federal agencies' interpretations. For instance, if the regulations were issued close in time to a statute's enactment, they were consistently interpreted by the agency over time, or the regulations rest on factual premises within the agency's expertise. There are 3 cases or rules that I'll be discussing later on that relate to the end of Chevron deference. The first is the Department of Labor's ESG rule and some of the challenges brought against that. This rule is illustrative of the end of Chevron deference and how with ending Chevron deference doesn't necessarily mean that challenges to federal agencies' rules will be successful. Although the district court relied on Chevron deference in its opinion when it denied a challenge to the 2022 DOL rule, at the Fifth Circuit during oral argument, it was suggested that reliance on Chevron won't necessarily be determinative for the case. And then 2 other issues or 2 other rules that are being challenged are the DOL's fiduciary rule and the FTC's non-compete ban, which I'll touch on more later. Second topic is the legal challenges to the preventive care mandate. The preventive care mandate was created by the Patient Protection and Affordable Care Act, called the ACA or Obamacare. The ACA requires non-grandfathered health plans to provide coverage for preventive care without cost sharing, health plans being group health plans or private insurers. And the ACA didn't define preventive care. It delegated that to 3 administrative bodies. They were tasked with issuing or recommending preventive care mandates. Those 3 bodies were 1, the Advisory Committee on Immunization Practices, called ACIP, 2, the Health Resources and Services Administration, HRSA, and then finally, the most important for purposes of the challenge was the United States Preventive Services Task Force, which I'll call the task force. And under the ACA, health plans were required to provide preventive care without cost sharing, and providing that without without cost sharing essentially means that the patients incur no costs for going to the doctor and receiving that care. And cost sharing includes deductibles, co-payments, and other out-of-pocket expenses, and co-insurance as well. So the task force is composed of 16 volunteer experts, and previously they were appointed by the Secretary of the Department of Health and Human Services. And this was a critical issue for the case because the plaintiffs argued that they should have been nominated by the President of the United States and confirmed by the United States Senate. And they argued that these volunteer experts were actually principal officers, which required them to follow the appointments clause under the U.S. Constitution. And one of the reasons why the court decided that they were in fact principal officers was that the ACA allows the task force to make A or B recommendations, which are evidence-based recommendations that a specific thing is preventive care. And when the task force had made those recommendations, the Secretary of Health and Human Services hadn't effectively reviewed those. So those recommendations became binding law on health plans. Some examples of A or B recommendations were certain cancer screenings, contraceptive services, and HIV prevention medication. The case was Braidwood Management v. Becerra. It was argued, or the decision came from the Fifth Circuit Court of Appeals. And like I said earlier, the plaintiffs argued that the ACA's preventive care mandate violated the appointments clause. And at the district level, they argued that they brought religious objections to the preventive care mandate as well. And they won those, but they didn't, the Department of Health and Human Services didn't appeal that at the appellate level. And initially, the district court in the Northern District of Texas actually issued a nationwide injunction, and the Fifth Circuit later reversed that nationwide injunction. Although the Fifth Circuit sided with the plaintiffs, the outcome of the case won't affect other group health plans right now because it reversed a nationwide injunction. So the only patients that won't have access to those preventive care recommendations are patients that are part of the health plans for the plaintiffs in the case. The next topic I'm covering is the ESG rule. And this one wasn't issued in 2024, but it's still a rather controversial rule by the Department of Labor. You might know what ESG means already. So it stands for environmental, social, and governance. And it's an investment strategy that focuses on the environmental or social impacts of a company's products or practices, or the company's governance structure. Over the last decade or so, there's been substantial growth in ESG investing, and not necessarily in like the returns for ESG investing, just the volume of assets managed by ESG funds. The main question is whether ERISA allows a fiduciary to select investments based on ESG factors. ESG is an umbrella term. It might mean one thing to one person and something completely different to another. For instance, when I think of a company like Tesla, I think that would likely be an ESG company because they make electric cars and those are environmentally friendly. But certain ESG managers might not consider Tesla an ESG company because they would have an issue with the governance structure of Tesla. So ESG generally, it has a conflict with ERISA in certain circumstances. ERISA requires two duties to be followed, one being the duty of loyalty and the second, the duty of prudence, among other duties. The duty of loyalty under ERISA requires fiduciaries to act solely in the interest of the participants and beneficiaries of the plan and for the exclusive purpose of providing benefits to participants and their beneficiaries. And the Supreme Court in 2014 held that the benefits refers to financial benefits, such as retirement income rather than non-pecuniary benefits. And then the duty of prudence here, I'll let you read that yourself. You can review that, and I'll go to the next slide. Previously, there were regulations in 1994 that allowed tiebreakers. So when competing investments serve the plan's economic interests equally well, fiduciaries can use non-financial considerations as a deciding factor for an investment decision. And then in 2022, under the Trump administration, they issued an ESG rule titled Financial Factors in Selecting Plan Investments. And this outlined pecuniary versus non-pecuniary factors. And under the rule, a pecuniary factor was a factor that a fiduciary prudently determines is expected to have a material effect on the risk and or return of an investment. And under the Trump rule, only pecuniary factors may be considered unless a fiduciary viewed two different investments and was unable to distinguish between the pecuniary factors, then they could potentially include non-pecuniary factors like ESG, but they had to document those factors in the case of a tie. And then in 2022, the Biden administration released their own ESG rule titled Prudence and Loyalty in Selecting Plan Investments and Exercising Shareholder Rights. This provided fiduciaries with more flexibility to consider collateral non-financial factors. And I have here that it modified the tiebreaker test, but it really just got rid of the documentation requirement from the prior Trump administration rule. And the rule itself was mostly just a tonal shift for fiduciaries because it had more friendly language related to ESG. For instance, it said that ESG factors may, not must, be irrelevant to the risk return analysis. And it said risk and return factors may include the economic effects of climate change and other environmental, social, or governance factors on the particular investment. This rule was published in November 2022. It's already been effective. It had an effective date of February 2023. And then for certain proxy voting policies that those came into effect more recently in December of 2023. This rule was ESG in general with ERISA fiduciaries has been relatively controversial. And like I mentioned earlier, there was an appeal of a district court's decision where the district court sided with the Department of Labor and their ESG rule. And this was filed by, I believe, 26 Republican attorneys general. And they argued that the rule was inconsistent with ERISA and arbitrary and capricious. But the case, when it went to the Fifth Circuit during oral argument, it appeared that the justices weren't necessarily going to side with the plaintiffs just because Chevron deference was overturned. But we'll still see. We're still waiting on an outcome in that case. The next topic is the Department of Labor's new definition of an investment advice fiduciary. The current definition of fiduciary under ERISA is that a fiduciary is a person with respect to an employee benefit plan to the extent the person, one, exercises discretionary authority or control, two, renders investment advice for a fee or other indirect compensation, or three, has any discretionary authority or responsibility in the administration of the plan. And because that definition isn't that helpful, there's a 5-part test as well. And this was created in 1975 by the Department of Labor. A person who provides investment advice to a plan for a fee is a fiduciary only if the person, and then it has 5 different tests here, of course. Namely, it mentions that the investment advice is to a plan specifically, and that it's provided on a regular basis, and that the advice will be individualized based on the particular needs of the plan. And the new rule issued by the Biden administration is titled the Retirement Security Rule, also known as the Fiduciary Rule. And it replaces the current 5-part test. It redefines an investment advice fiduciary for purposes of ERISA. And it takes a rather expansive view of what a fiduciary is under ERISA. The purpose of the new rule appears to be to include more advice from financial advisors or insurance professionals, especially in the context of individuals who are seeking to roll over funds from their workplace retirement plan into an IRA, or rollover funds from their workplace retirement plan into an annuity or something like that. And before, there was a loophole for one-time advice offered by an investment professional where that wasn't considered, they weren't considered a fiduciary under the five-part test because I'll go back one slide, but that had an element of the advice being offered on a regular basis. So one-time advice like that, if you rolled over your funds from a workplace retirement plan, wouldn't necessarily be covered by the prior test. And the effective date for this rule is September 23rd, 2024. It's been a rather controversial rule, so there's lots of litigation involving the fiduciary rule right now. And here is the actual fiduciary rule that the Biden administration issued. It says a person is an investment advice fiduciary if one, they make a recommendation of any securities transaction or other investment transaction or any investment strategy to a retirement investor for a fee or other compensation, including direct or indirect compensation. And then the recommendation arises in one of the contexts that they outline. And notably, if a person represents that they are acting as a fiduciary, they're not able to disclaim their fiduciary status under this rule. So the Department of Labor was concerned with advertising where financial advisors were saying that they were going to operate in the best interests of individuals and have individualized planning for them, and then they would disclaim their fiduciary status in the fine print. So they're not allowing them to do this under this rule. And then for the first part of the rule is that if the recommendation indicates that it's based on the particular needs or individual circumstances of the investor, or it reflects the application of professional or expert judgment, or they indicate that it's in the best interest of the retirement investor, those all suggest that they are fiduciary under the new rule. Already, there's been challenges to this rule. First, there was a case brought by trade associations for insurance companies in the Northern District of Texas as well. They argued that the rule faces the same issues as the 2016 fiduciary rule under the Obama administration, which was struck down by the Fifth Circuit. They said the rule is too broad and would put sales into a fiduciary context. And they also argued, among other arguments, that the rule violates the major questions doctrine. And the DOL's counter-arguments was that Congress expressly granted the DOL the wide authority to grant exemptions and to interpret the term fiduciary in ERISA. The next topic is the FTC's non-compete ban. This is the final topic. It's rather important because, as I'll get into later, this non-compete ban by the FTC's own estimates would affect 1 in 5 U.S. workers. It was issued this past spring and has an effective date in September of 2024. So it hasn't gone into effect yet, but it's received a lot of legal challenges so far. And the rule prohibits an employer from entering into or attempting to enter into a non-compete clause with a worker or representing that a worker is subject to a non-compete clause. And a worker includes both an employee and an independent contractor. The rule would prohibit all agreements that have the same functional effect as a non-compete agreement. So if there's an agreement that, although it's not titled a non-compete agreement, and it serves to prevent a former worker from obtaining post-employment work in the same field, that's likely going to be viewed as a non-compete agreement as well. There's some notable exceptions to the non-compete rule. First, it doesn't apply if there's a bona fide sale of a business entity. 2, existing non-competes with senior executives are not prohibited under the rule, and the rule won't apply to nonprofit organizations. The rule defines senior executives as those who are making $151,164 in annual compensation, and that person is in a policy-making position for the business. And like I said earlier, existing non-compete agreements with those senior executives remain enforceable. But notably, after the effective date of the rule, all non-compete agreements with all workers, including senior executives, are prohibited. An important part of the rule too is that the employers must provide notice to workers who are subject to one of those prohibited non-competes, and it must be clear and conspicuous that the employer will not enforce the non-compete, and it cannot legally enforce that non-compete agreement against the worker. And this notice must be provided in an individualized manner. For instance, the rule gives examples of forms of notice that are acceptable, like sending a letter to the last known address for the worker. An employer couldn't just post a bulletin in the lunchroom and satisfy that notice requirement, and that notice must be provided by September 4th, 2024. As I referenced earlier, the non-compete ban appears to be rather sweeping and it would have large economic impacts across the United States. In the FTC's own words, it covers 1 in 5 US workers, and they estimate that it would generate 400 billion to 488 billion in increased wages for workers over the next 10 years. And one thing that stood out to me was that they estimate that it would reduce spending on physician services by 74 billion to 194 billion dollars. So they seem to have an eye towards the healthcare industry here, because that's quite a substantial amount of money that they're estimating just for doctors alone. So far, one of the main cases that was a legal challenge to the non-compete ban was Ryan LLC versus the FTC. This case was filed in the Northern District of Texas as well. I think every case I've mentioned so far was initially brought in the Northern District of Texas, and the district court granted a preliminary injunction, and they postponed the effective date of the rule. But importantly, they postponed it only for the plaintiffs. And they held that the FTC lacks substantive rulemaking authority with respect to unfair methods of competition. And they also promised to issue a final ruling on the case by the effective date of the non-compete ban. So we have that to wait for. And now I'll open it up to questions. I think I already have one. And if you have any more questions, feel free to ask them in the Q&A feature. So the first part of the question is, for the fiduciary rule, would that include employer representatives who help employees with questions regarding 401k? And that was actually a concern of the Department of Labor, because certain trade groups or organizations actually brought that complaint, and the Department of Labor has said that they didn't write the rule to include employer representatives who help employees with questions regarding 401k, but I understand the concern there, because that would be offering an advice, but I'd have to go back and review the rule in greater detail, and I can reach out to you, but I don't think it would cover employer representatives. And then employers who are responsible for administering the 401k plan, they're not covered as well. There might be a specific prohibited transaction exemption that covers both of those examples, but I would have to go back and look. And I have a few non-competes. I'll just pick one of the questions here. It's non-compete notices must be completed by September 4th, the person asked. And they said, is it possible that this rule will change given any legal challenges happening now? And yeah, under the rule, they would have to provide notice by September 4th. But like you mentioned, there's a lot of legal challenges right now. So it's a little too early to say whether or not you would actually have to bring notice by September 4th. I think it's fair to wait and see what the outcome of the litigation will be. And I'll look through here for any more. There was a similar non-compete question, but The the answer is that the case I referenced, that only prevents enforcement against the plaintiffs in the case. It's not a nationwide injunction at this point. And I'll leave it open for a few more seconds if anyone has any other questions. But until then, I think I got them all, and I'll review any I might have missed after this presentation as well. It looks like I got one more non-compete question, and it is the non-compete ban enforceable for all non-compete agreements? And are there any non-compete agreements that are excluded from this ban? There are certain employers that the FTC lacks jurisdiction to issue rules for, like nonprofits. So I think that might be what you're referencing there. And then, like I touched on earlier, there's in a situation where there's a sale of a business, you can have a non-compete agreement, and non-solicitation agreements and things like that. Those you can still have. And also, this is just for post-employment non-competes. If you're currently working for an employer, generally you can't compete in business with them at the same time. This would not cover that kind of a situation. So I think I've asked or answered all of the questions. If you have any more, you can reach out to me at my email or give me a call. But for now, I think we're all set with this webinar. So have a great day, and thanks for attending.